Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II.
Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II, principal at Carter Arnett in Dallas. Bob has more than 35 years of experience handling complex business, intellectual property, and real estate disputes in Texas and federal courts nationwide. I'm Lisa Mosby, your host, and today we're discussing summary judgment in Texas business litigation and how cases can be resolved before reaching trial. Welcome, Bob. Let's get to what people want to know, shall we?
All right. Good to be here.
Bob, in commercial litigation, what characteristics tend to indicate that a case may be resolved at the summary judgment stage?
Well, in summary judgment, there has to be no genuine issue of material fact. And if that's the case, then the case is susceptible of summary judgment or resolution by summary judgment. So typically think of a promissory note case. You have the promissory note, it says what it says. The borrower has made payments or not made payments, and there's generally, those are generally facts that aren't in dispute. And so, that kind of case frequently is resolved at summary judgment. Other collection cases can fall into that same category. Lease disputes, which generally revolve around non-payment of rent, also fall into that category. As well as other cases. I think contract cases are more susceptible of summary judgment than tort cases, although in some circumstances, tort cases, if there's really a legal issue like a causation type issue that's there, those can be resolved at summary judgment. So really, it's the nature of the underlying case.
So, Bob, does the summary judgment process function differently in Texas state court compared to federal court?
Well, the standards are the same. It is there a genuine issue of a material fact? But the approach is somewhat different. I would say that as a general rule, most federal judges are more inclined than Texas state court judges to grant summary judgments. In part, I think that's because federal judges have the luxury of law clerks that the Texas state court judges do not. I guess in rare instances you can have a Texas trial level judge that has, maybe shares a staff attorney with somebody, another judge. But for the most part, the state court judges are on their own in terms of reading papers and doing research to understand the party's position. So they're a little less inclined to grant summary judgments. I had a hearing not that long ago, and we had a visiting judge who was telling us that he was now in his 62nd year of practicing law. So you figure out how old this gentleman was. But so by a visiting judge, so that means he's no longer a sitting judge. He was elected to, a bench at probably some long time ago in the past, and then either retired or decided not to run again. But is still available to be appointed to sit as a visiting judge in cases. And he told us, when he was on the bench, I guess he did say he was on the bench for 24 years. So, good long tenure, that he had never had a summary judgment that he granted that got affirmed by the appellate court. So he was not really inclined to grant them anymore. So, unfortunately, in that case, I was the one that was opposing summary judgment. So he did, in fact, deny that motion, which was good for me. But that maybe gives you a little insight into how some Texas state court judges view summary judgment.
Which types of claims or defenses most commonly lend themselves to resolution through summary judgment in business disputes?
So the claims that are most typically resolved by summary judgment are in broad category breach of contract, particularly where it's a fairly defined subject matter of the contract, like a note case. This is a promise to pay X dollars by Y date, and either that was done or not done, and therefore, if it was not done, then summary judgment should be granted in that circumstance. Or a lease dispute, commercial lease dispute. The tenant's supposed to pay rent of X dollars every month, and if they fail to pay it, then the lease provides for remedies under that, and you should be able to get summary judgment. From the defense side, one of the defenses that is susceptible to summary judgment is the statute of limitations. In other words, the plaintiff has a certain amount of years to bring a claim after the claim accrues. In other words, that they are able to bring the claim. And so for breach of contract, that's 4 years. If you wait more than 4 years, then your claim is barred by limitations. And I've seen a lot of defense motions for summary judgment on limitations that are granted. In the construction realm, there is a statute of repose statute of repose is hard and fast. I mean, limitations can be subject to what's called tolling. In other words, it's been 4 years, but you get a little extra time because, there's either the discovery rule or maybe there's allegations of fraudulent concealment or other sort of tolling. But, repose is, and that's generally for construction matters. If the 10 years has passed, the 10 years has passed and you're done. So, those time barred claims, that is something that can be disposed of at summary judgment.
And then how does the factual record developed during discovery influence the likelihood of success on a summary judgment motion?
Well, I mean, I guess as the factual record develops, if somebody is trying to create a fact issue that would preclude summary judgment, and sometimes, in response to a summary judgment motion, the defendant will just put in a whole pile of evidence, a big stack of documents, and say, look, Judge, there's got to be a fact issue in there somewhere, that has limited utility, really. But, it depends on what the potential summary judgment motion is about. If you go through, let me give you another example. So there can be business torts, like business disparagement, or tortious interference with contract. And if you depose the person that, or the company representative who is bringing that sort of claim, and they just have no evidence on some essential element of the cause of action, like, no direct evidence that a defamatory statement was made, or it's just hearsay that would be inadmissible at trial, and inadmissible on summary judgment, then, once you take that deposition, you've got the deposition in the can, you're set up for a summary judgment motion.
That makes sense. From a strategic standpoint, what considerations go into deciding whether to pursue summary judgment versus preparing a case for trial?
Well, at least, in my practice, I treat every case like it's going to go to trial eventually.
Okay.
Because really the best way to get a case settled is to be ready to go to trial. And that's on either side, whether you're plaintiff or defendant. But, considerations that go into whether to file a summary judgment motion, you may want to do it even though you think you're probably it's not going to be granted, because it's a good way of getting the other side to sort of marshal their evidence, and you now find out what their case is all about. Whereas, discovery people tend to be, non-responsive or somewhat enigmatic, or, they make a whole bunch of objections, and you don't really get the full story of what they think their case is, or what do you think their strong points are. Summary judgment will flesh that out, because they need to put their best foot forward, or their case is going to get thrown out. So that's a factor. On on the flip side, there's sort of the expense factor. If you really think that that there's going to be a fact issue, or it's too easy for the other side to create a fact issue, then, why go through the expense of doing it? You may want to set it up for, later on down the road, sort of use it as an educational tool for the judge, because you may not get it at summary judgment, but you may get it on a directed verdict after the plaintiff has had a chance to present their evidence. So those are some of the considerations about whether to bring a summary judgment motion.
Sure, that's a lot of strategy thought that goes into that, whether you're going to move forward with it or not. So, how do judges approach competing evidence and maybe legal arguments at summary judgment stage?
Well, competing evidence. So, there's the standard is there's no genuine issue of material fact. But there's a couple of points to that. One is it's got to be a genuine issue, and let me give you an example of what I mean by that. So in Section 1983 actions, like excessive use of force against a police officer, you can have video evidence, surveillance video, either body cam footage, or if it's within a correctional facility, surveillance camera footage that shows what happened when the plaintiff claims that he was brutally assaulted by police officers. And if the footage, the video footage, is conclusive that things happened in a certain way, it doesn't matter if the plaintiff puts in an affidavit claiming something different. The video footage is conclusive, so that's not a genuine issue, and so summary judgment can be granted, in those circumstances. And the other one is it a material fact? In other words, does it matter? So typically you would put in affidavits or declarations of people to establish what the facts are to support your summary judgment. And the other side will then put in affidavits or declarations of their witnesses to try and create an issue of fact. Well, not everything that goes into an affidavit is material, or it matters to the ultimate decision. It may be some completely inconsequential point that somebody wants to argue about, but that's not something that's going to prevent you from getting summary judgment. As an example, the case I've going on now, this is kind of a smallish case, but so somebody sprayed a dog with mace and was, the affidavits that came in, the person that owned the dog said that he was walking the dog with his wife, and the other side maintains that no, the wife wasn't there. Well, what really mattered was, did you mace the dog or not? Whether the wife is there or not is completely immaterial, because she didn't put in an affidavit. It was just sort of an incidental fact. So that's an example of something that where there's a dispute, it's not material. It doesn't matter, and it doesn't prevent you from getting summary judgment.
So, Bob, I've heard the term partial summary judgment. When a partial summary judgment is granted, how does that reshape the remaining issues and the overall posture of the case?
Well, there can be a couple different kinds of partial summary judgments. It can be, partial in the sense that it's disposing of some but not all of the claims. Or, for example, a plaintiff can move and get summary judgment on the defendant's counterclaims, but not summary judgment on their own claims. And so, that does change the dynamic of the case, because now, the plaintiff has no downside and the defendant has no upside. It's just the case has been reduced to simply the plaintiff's claims against the defendant. So that's one circumstance. The other is a court can grant partial summary judgment in the terms of not necessarily disposing of claims, but disposing of important issues, deciding, for example, what a contractual provision means as a matter of law. So this is what this contract means, and this is how we're going to view the claims when they get in front of the jury. The jury's going to be instructed that this is what this contract means. So that Obviously, if the two sides are arguing for different constructions, even though there may be other facts that the jury needs to decide, the fact that the judge has agreed with one side or the other's construction can have a major impact on the viability of the claim going forward.
And how does the timing of the summary judgment motion influence leverage between the parties as the case progresses?
So, an early summary judgment, typically if it's a plaintiff doing it, they just, at that point, they want to get their judgment. They want to get, a final judgment and proceed on to collection. If, it brings the defendant around to the table, I think that most plaintiffs in that circumstance are not going to be, interested in discounting what they think their claim is worth, unless there's a real issue about collectability, or there's a danger that the defendant is going to file bankruptcy. So, that's early summary judgments. Texas has just adopted some changes to the rules of civil procedure that now require, they put time limits on the state court judges to decide summary judgment motions from the date that they're filed. So you can no longer have a summary judgment motion that is just pending for months and months and months and months. So, that's going to change the dynamic somewhat. The Dallas courts have adopted a local rule that requires that summary judgment motions now be filed. I think it's no later than 90 days before trial. It's, previously was the rule that summary judgments had to be heard 30 days before trial. So that meant that you had to get it filed in time to give the other side 21 days notice of the hearing, and then, hope that you could get a hearing within that time frame. But now it's that the new rule is going to back things up considerably from your trial date. So you're going to have to get your motion for summary judgment on file a lot sooner than you otherwise would have. The pendency of a summary judgment motion, in terms of how much leverage it creates, is really fact specific. It's, you can file it and the other side is going to go, okay, well, there's no problem in beating that. I can certainly create a fact issue on that one. Or, it may be something, like limitations or the statute of frauds or some other really, a defense that's going to completely put you out of court if it's granted. And so then that may create some leverage to try to get the case resolved while that summary judgment motion is pending. So the pendency of a summary judgment motion, say, for example, you're going to mediation and there is a case dispositive motion that's pending. It's waiting for a decision. And if you're, on the receiving end of that, that may be something that incentivizes you to get the case settled rather than risk getting a negative result.
I think that's where we'll leave it today, unless you have any final thoughts on summary judgment.
No, it used to be considered a disfavored practice in both state and federal courts. But, the U.S. Supreme Court, starting in probably the mid-'80s, 1986, has decided, a bunch of cases that say, no, this is not a disfavored procedure. This is a part of the civil rules that allow you to get cases that shouldn't go to trial disposed of early. So you need to, you judges need to, take a good look at them and utilize this procedure when it's available. And I think that the trend is coming around to the state courts as well.
Well said. Thank you so much for your insights today, sir.
All right. Good talking with you.
Folks, that's it for today's episode of the Texas Commercial Litigation Podcast with J. Robert Arnett II of Carter Arnett. To learn more about Bob and his firm's work in business and intellectual property litigation, visit carterarnett.com. Thank you so much for listening, and remember to leave a review, and subscribe to the show so you don't miss the next one. We'll be there. See you there.
Thanks very much.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.